last week when Richard Sprague was my guest, if you'll recall. I read from the New York Times account briefly of what had transpired in Tennessee relating to the escape trial of James Earl Ray, and made reference to Judge Lee Asbury's forbidding Ray's new attorney, Mark Lane, from discussing, quote, the previous judgments or the original conviction, unquote, Judge Asbury. Since, as you know, the purpose of this show is to do that which the media has continually refused and failed to do, to inform the people of the relevant facts surrounding these cases. It is with great personal pleasure that I speak with and have you listen to Mark Lane. Welcome to the show, Mark. Pleasure that I speak with and have you listen to Mark Lane. Welcome to the show, Mark.
Thank you, Ted. Nice to be here.
And as you know, you have a standing invitation to appear in person on my show anytime you're in New York. Would you please tell the people, because the coverage here is very sparse, just a few buried articles in the New York Times just saying that Ray was guilty after a 3-hour jury deliberation. But would you tell the people what has transpired in Tennessee and what might transpire there in the future in reference to this, Mark?
Surely, the fact that the jury deliberated for 3 hours is, of course, very significant. In Morgan County, Pennsylvania, Morgan County, Tennessee, where the trial took place, that's a long time. The jury is generally chosen, the trial conducted, the jury charged, the jury retired, and the verdict comes in. Generally, all of that takes place in less than 3 hours, and the jury verdict generally takes between 10 and 15 minutes. Even in somewhat complicated cases. That's the way it's done relatively quickly in Morgan County. James Earl Ray testified. He said he did go over the wall. He said he deliberately escaped without permission, and he said the reason he did that is because there was no way to get any attention focused on the questions that he'd been raising for 9 years about the murder of Dr. Martin Luther King, and because for 9 years in the state of Tennessee and in the federal courts, he's done everything in his power to have a trial. He never was tried for the murder of Dr. King. There was a coerced plea was entered on his part. I believe after he had been tortured psychologically and physically, he then entered the plea of guilty, and by doing so, he was denied an opportunity to be tried, and by doing so, the state of Tennessee and the federal government, which was deeply involved in the coercion and the physical and psychological torture of Mr. Ray before he entered the plea, the federal government denied to all of the American people an opportunity to hear the evidence adduced against James Earl Ray regarding the murder of Dr. King, presented in a courtroom and subjected to cross-examination. And Ray said that when he went over the wall, he planned to, if he made it out of there, he planned to agree to surrender if the state agreed to give him a trial for the murder of Dr. King. And when the man is charged with climbing over the wall without permission, and that's the whole charge, and then he gets up in open court and testifies and said he did leave, he did escape. For the jury to be out for 3 hours under these circumstances is quite an indication that the jury was thinking about other things. And they were. In my closing argument to the jury, I said that although the court had foreclosed what was our basic area of defense being that Ray could not be charged with legally leaving a legal confinement, because the statute certainly must show that Ray was properly confined at the Brushy Mountain, Tennessee Penitentiary. If they couldn't show that, obviously then they cannot show that he did anything unlawful when he left. It was our position that we were not going to retry or try for the first time the case involving the murder of Dr. King, but we thought, going to raise the question of the legality of Ray's confinement, not the question of whether he was guilty or innocent, but whether or not he was coerced and illegally coerced into entering the plea of guilty, and the court said that we could not do. And I said to the jury that, there are areas that are foreclosed, and you're supposed to not know about anything else, but you weren't all born on Mars, and you weren't all transported here to Wartburg, Tennessee. This afternoon, you all have lived in the state, and you've lived in this country, and you know what happened on April 4th, 1968. And so I'm going to ask you to send a message to Washington, D.C. by deliberating as long as you think is appropriate, and by giving James Earl Ray the minimum sentence, because that will be sending a message to Washington that you want the basic facts regarding the murder of Dr. King to be aired. And the jury was then out 3 hours, and they came back and they gave him the minimum sentence of 1 to 2 years. Now, what was most significant is that reporters for newspapers in Tennessee, I don't know if this is published in the New York Times, with the rest of all of the news that's print, but I do know that it's been published widely throughout Tennessee in the leading newspapers in Nashville and Knoxville and the other leading newspapers in large cities with leading newspapers, and that is a series of interviews that was sent out by the AP and the UPI. Series of interviews with jurors who came out saying we deliberated so long because we were trying to find a way to do what Mr. Wayne said that we should do. That is to send a message to Washington, because all of us have doubts about the murder of Dr. King, and all of us want the government to do something to resolve those doubts by giving James Earl Ray a new trial, or a trial regarding the murder of Dr. King. So that's what the jurors were thinking, and that's why they deliberated so long. And I think some of the national news media, for the first time, some of the network television news programs indicated this was so. This was really a victory for the defense. We weren't really concerned about James Earl Ray being sentenced to some additional years. He's already sentenced to 99 years. What we wanted to do was to responsibly raise it. And I would say that we raised it in such a fashion that we very deeply upset the Attorney General of Morgan County, Mr. Carson, because when I said that we should the jury should send a message to Washington, he stood up and said, if you will quit this now, you'll be sending a message to every single prisoner right here in the penitentiary, which is right near where your homes are, and the message will be, come on out, nothing will happen to you, and they will come over the walls and go into your homes, he said to the jurors. Well, as I got up when I made my motion for mistrial and said that, one could hardly think of anything. In fact, I can't think of anything which would be more improper for an attorney general to say to a jury than what he said. He was appealing to, he was seeking to inflame them, to frighten them, to appeal to their prejudice, appeal to the fact that they live near the penitentiary. And, of course, the only thing that a district attorney or attorney general can say in indicating to a jury why they should find the defendant guilty, the only thing that he can say in terms of motivation for the jury to find the defendant guilty is that because he believes, and he hopes that they will believe, that the evidence establishes beyond a reasonable doubt that the defendant is guilty. There can be no other reason given to a jury by a prosecuting attorney as to why a jury can convict. And so what he said was the basis for mistrial. Without question, the judge not only did not admonish him not to continue, he merely said, well, don't try to contain your emotion. He never tried to correct the situation by telling the jury that they should not take into account what the district attorney said. So there's no question in my mind but that if we appeal that case, and we are filing a notice of appeal within the next 2 weeks, when we appeal that case, that the verdict will be overturned. And why? Because the Attorney General was so concerned that the jury was actually perhaps even going to acquit the defendant that he felt compelled to do something which obviously was improper in order to avoid that result. We'll try that case over again, very likely. But what's much more important and much more meaningful to us is what we sensed throughout the state of Tennessee, wherever we were and wherever the reporters came from, and that is a growing concern with the fact, with the basic fact that they don't know who killed Dr. King and why it happened. And I'm confident that if we ever try that case in Tennessee, if James Earl Ray really is ever tried for the murder of Dr. King, that we will win that case. Now, in addition to this, we know that the House Committee on Select Committee on Assassinations has uncovered, according to its chairman, Louis Stokes, blockbuster information, startling new developments. And the King assassination, I think I know what they may be, very well be, but I don't think it's appropriate for me to talk about them because Mr. Congressman Stokes did not release that information. I can say that the House Select Committee will be coming to the penitentiary. I'll be meeting them there at 9 o'clock in the morning on November 14th for a long, in-depth interview with James Earl Ray on that occasion. And that matters of great significance, which have not even been touched upon before, will be explored there. And I can tell you that in terms of what we have uncovered in the last week working together in Tennessee, We were there for the trial, but we were doing other things as well relative to the overall case. What we have uncovered is so startling that when it is released, people of this country are going to be astonished when they discover what it is that we uncovered just recently. That information will be made available to the House Select Committee in the very near future. In addition to this, I will say that we are now making arrangements. I've already talked to the attorney for the House of Representatives Select Committee on Assassinations in charge of the King case, and we are making arrangements for independent authorities secured by the House Select Committee to question James Earl Ray in the presence of a polygraph operator, that's a lie detector operator, and that test, the polygraph test, the lie detector test, will then be analyzed by the experts, for the independent experts secured by the House Select Committee on Assassinations. That in addition to that, that testimony will then be subjected by the House Select Committee to experts in the area of PSC, which is psychological stress evaluator, which is a similar technique to the polygraph test, and that the results, which the House Committee is not allowed to reveal, in fact, they're not even allowed to say that anyone has been subjected to that testing, but of course we have the right to do that, and we are saying in advance that whatever the results show, I will release that material to the press, and of course we have the right to do that. We're not compelled to do it, but we will do that. So that is one thing we will do. The second thing we will do is, as I said, we are filing a notice of appeal for a new trial in the escape case, and the third, and of course the most important thing for us and for the country, I think, is that we are filing under a provision of the Tennessee statute calling for post-conviction relief. That statute which has not been employed, although it could have been employed before now, regarding some of the important elements of the case. We are filing for a trial for James Earl Ray regarding the murder of Dr. King. We are optimistic. We believe that there is a very good chance that such an application will be granted, if not on the original level where it's filed, perhaps on an appellate level. We believe that within the year, James Earl Ray, within a year from now, James Earl Ray, we believe, we hope, will be tried in Memphis, Tennessee, for the charge of murdering Dr. Martin Luther King. And when that happens, I think that for the first time, before the American people, the key witnesses will come forward, will give their testimony, and will be subjected to cross-examination for the first time. And from that trial, I believe the American people will learn a great deal about the murder of Dr. King. And anyone who is interested in participating in the development of such a campaign can write to me, and I'll get that material on. I believe that there will be, to the appropriate people, I believe that there will be an office set up by national religious leaders within the next few weeks. But in the meantime, anybody interested in participating can write to me. It's Mark Lane, 715, that's 715, Oceanfront Walk, Venice, California, 90291. I'm sure if you call Ted or contact him, he can make the material.
And I will be repeating that subsequently and often. I would like to mention the fact that I have talked to Congressman Stokes last week, and he assured me in the telephone conversation that the report of the House Select Committee on Assassinations will be released, definitely, he said, and that by the time the government printing office does print it, it might be January until we receive that, until the American people are made aware of some of the investigative procedures and knowledge relating to their investigation. So I have been assured by Congressman Stokes that the report will be released. Do you feel, Mark, as a person who has studied these cases at least as long as anyone else and longer than most, that the House Committee on Assassinations will be revealing materials which would not come to the forefront of the attention of the American people because of the non-reportage by the media?
I think that some of the material is so startling that when they do release it at a press conference, I'm sure there will be a press conference. I presume there'll be a press conference when they release their document.
By the way, Mark, in reference directly to that, I think you might be interested, and the people might be interested in knowing that 3 hours before I did the show this past Friday with Richard E. Sprague, I received a call from John Crutzen. He had corresponded with me in a letter that I had forwarded to you, as you know. And but he called me 3 hours before the show, and And I asked him if I could tape record the conversation for future reference, and he allowed me to do so. And this is something that I've not mentioned to anyone, and this is the first time that I'm mentioning it on my show, of course. But he did, I just alluded to it very quickly in passing on the last show, not in depth, but he told me, he told me on the show, during the phone conversation, he said, if you could give me any, listen to this, he said, if you can give me any information, or anyone could supply me, and I have the tape, with any information which disproves the conclusions of the Warren report, which indicates either he's Neanderthal man or what, but he said, I promise you as a man, I will have it published in the New York Times. I said, would you repeat that, please? And he repeated that statement. I said, you'll give me your word of honor as a man? He said, yeah. I said, I have heard that a couple of years ago, a researcher, and I did not mention any names, supplied you with information relating to several aspects of the case, including the Ruby affiliations with the FBI, and you refused at that time to publish it. Why should I believe that you would do it now? And he said, well, I've never heard of that, and I've never been supplied with that information. There is no evidence that I've seen or in the possession of the New York Times that disproves any conclusions of the Warren Commission report. I have since then talked to various other researchers, like Sylvia Moore, I mentioned it to Richard Sprague, various other researchers, and I'm getting from them, I'm requesting from them information to send to John Crutzen, including some of the original tapes that I have, and so that we can counter the nonsense which he has told me that the New York Times has never been any information, and that there is no information to his knowledge that disputes the main contentions of the Warren report.
Well, nobody any longer can take anybody seriously who says anything like that.
Yeah.
That there's no evidence which contradicts the Warren Commission report. The Church Committee of the United States Senate, and a report signed not just by the now Vice President Mondale, then Senator Mondale, by Frank Church of Idaho, by Senator Baker, now the leader of the Republican Party in the Senate, but also by John Power of Texas and Barry Goldwater of Arizona, report signed by all of these men, said that the investigation by the Church Committee revealed that the CIA and the FBI at the very highest levels, and these are the agencies relied upon by the Warren Commission, because as we know, the Warren Commission did not hire a single investigator, stating as in their report that they didn't do that because they were going to rely upon the existing organizations, primarily upon the Federal Bureau of Investigation, and to a certain extent upon the CIA. Well, now we have the Church Committee report on this question, saying their investigation revealed that both the FBI and the CIA deliberately deceived the Warren Commission, suborned perjury, committed perjury, destroyed evidence, and in fact invented evidence to mislead the Warren Commission. So when you find that the Warren Commission's investigators, upon whom they relied, lied to them and made a deliberate effort to deceive them, and then you can still say, well, I agree with the Warren Commission's conclusion anyway, you have to have a mystic view of how the Warren Commission got the truth, because they didn't get it through their own investigators who they relied upon, who were lying to them. First of all. Secondly, I called Mr. Crutzen some time ago, about a year and a half or 2 years ago, perhaps. We were having a press conference. I was at the Citizens Commission of Inquiry in Washington, D.C., of which the director was having a press conference, and we invited the news media, of course, and Crutzen called me. After we had placed the call to him, he finally called back, and I said, are you coming tomorrow? And he said, well, what's it all about? I said, well, we sent you the advance notice. He said, yeah, but I have to know what all the details are before I come. And I said, well, I can give you the details about what we're going to release at the press conference, but I don't want you to release them in advance. It won't be fair to the rest of the news media that are there. He said, well, unless you can give me something really hot, I'm not going to come. And I said, all right, as you know, one of the essential positions taken by the Warren Commission determining that Jack Ruby was involved in no conspiratorial relationships regarding the murder of Lee Harvey Oswald, one of the areas the Warren Commission was investigating. I said, as you know, the Warren Commission made it quite plain that Ruby never had any connection with the Federal Bureau of Investigation. I said, we have now secured documents which have been hidden for all of these years, which show that Ruby worked for the FBI, and that in 1959, 4 years before he killed Lee Harvey Oswald, that he met with the FBI agents on a regular basis every month for a period of 9 months, and that the Warren Commission was never told this. The reason the Warren Commission denied that Ruby had a relationship with the FBI is because the FBI lied to the Warren Commission and did not make some of this basic information available. That is to say that the commission itself, the individual commissioners never got the material. Some of the material was sent by Mr. Hoover to J. Lee Rankin, the general counsel of the Warren Commission, and Rankin decided not to share that information with the Warren Commission. It was not published in the 26th volume, and above all, it was not given to the two lawyers for the Warren Commission, Leon D. Hubert Jr., former district attorney of New Orleans, and Bert Griffin of Ohio, who's now a common pleas court judge in Cleveland. These are the two men assigned by the Warren Commission to look into Jack Ruby's background, and these are the two men who wrote the portion of the report which said, in essence, Ruby had no association with the FBI because Rankin refused to give them the evidence which he had received. And if you talk with those men, they will say that they were deceived. They were deceived by the Commission and by the FBI. And if they had had that information, they would have called in the agents for whom Ruby had worked, questioned him, questioned each of the agents for whom Ruby had worked, demanded reports of all of Ruby's reports to the FBI, and it would have been an entirely different story. And I told that all to Crutzen, and Crutzen said, well, look, we know that Ruby worked closely with the FBI. In fact, we know that the FBI agents always hung out at his bar in Dallas. And I said, well, it's not true. The FBI hung out at his bar in Dallas. I said, I guess you've never been to the place. Perhaps you believe what the New York Times said about it, that Mr. Ruby was a nightclub proprietor. It was a sleazy strip joint with sawdust on the floor, and they served beer and nothing but beer, and not even in a glass, right in a bottle. It was not the kind of place where FBI agents hung out. In fact, if an FBI agent was caught in there, except on official business, because of the relationship with Ruby, the agent probably would have been fired if Hoover ever heard about it, because it's just exactly the kind of place that Hoover felt FBI agents should not hang out in. So you're wrong about that, I said. But I said, in any event, the New York Times endorses in toto every conclusion, every false conclusion of the Warren Commission, and they've done that since the first moment the report was rumored to be coming out, and regularly since then have attacked every book and every writer and author and investigator who has raised any serious questions about the report. And I said, and now you tell me the New York Times always knew that Ruby had a relationship with the FBI? I said, the readers of the New York Times don't know that. And he said, well, don't tell me about what the Times did in 1963. I was only about 12 years old, but you can't blame that on me. I said, well, you have a very personal view of journalism. This is a historic event, and I'm telling you about it. He said, well, I'm not going to come to the press conference because that's of no significance. Now, if Mr. Crutzen says, apparently he said to you, that no one has ever shown him any information which is contrary to any of the conclusions of the Warren Commission, one can say that Mr. Crutzen either has a very, very poor memory or something worse is involved here.
And he also, by the way, I have my pitch saying it, he referred to the CIA document dated April 1967 entitled Counter and Criticism of the Warren Report, and which I had sent him, as I mentioned, and he said to me on tape that he had talked to somebody in the CIA and that they questioned the authenticity of that document.
Well, Mr. Crutzen is in a lot of trouble. I can tell you that. It's a document which you ultimately got because I had it released by the CIA. Is that right?
That's right.
Document?
Yep.
I have over 65 pages of documents which I have received under the Freedom of Information Act, an action brought jointly by me as the director of the Citizens Commission of Inquiry and by the American Civil Liberties Union, functioning through their Washington, D.C. office. And we have letters from the general counsel of the CIA which accompanies this material, and this is material which the CIA has itself released. And more than that, the documents that document that you're referring to, together with other documents, telling how I was to be destroyed and I was to be discredited, and that the other critics of the commission would be destroyed and would be discredited, were released, as it says on the documents, to the chiefs of stations of the CIA throughout the world, with book reviews of Rush to Judgment, which were prepared by agents of the CIA in Langley, Virginia, all for the purpose of discrediting me and preventing my views and the views of other critics from being heard on this question in every country throughout the world. Release it, it said, to our elite contacts in government circles in every country throughout the world. Release it to our contacts in the book review sections, feature writers and editors of important publications in every country throughout the world. Not only do I have all of that stuff, but a few weeks ago, here in Los Angeles, I debated David Phillips, David Atlee Phillips. He was the director of the Western Hemisphere for the Central Intelligence Agency at the time of the assassination of President Kennedy, which, as we know, took place in the Western Hemisphere. And I confronted Mr. Phillips in front of the news media and professors and scholars and students from all over this area. I confronted him with these documents, which Mr. Crutzen now wonders whether or not they're real documents which we got from the CIA under the law ordered by the court to release this material to us. They gave us this material, and
there's no doubt about
what Mr. Phillips said. Mr. Phillips looked at it and said, "I apologize for what we in the CIA did to Mr. Lane. We should not have sent out that material. And later, during the question period, a man named Peter Samuelson, the film producer, stood up in the audience and asked Mr. Phillips if he had ever seen those documents before. And his answer was, yes, I read those documents. He referred to it as the book plate. It's a phrase I'd never heard before. He said, yes, I got that book plate material, which Mr. Lane has raised. I got that material by when I was in Caracas, Venezuela. That material, which Mr. Lane and which you have referred to, came across my desk there. So it's just no question that is true. More than that, a Baltimore paper, the Baltimore Sun, some months ago, ran a front-page, major headline story about those documents, and before doing that, the reporter who wrote the story called the Central Intelligence Agency and asked them if they would, first of all, authenticate the documents, and secondly, if they had a comment on what the CIA had tried to do to me and other critics of the commission. And the CIA did authenticate the documents and made no comment about the propriety of their having done what they admitted they did do. If Mr. Crutzen of the New York Times can find a reporter someplace in New York City, perhaps they can call the Central Intelligence Agency and do just what the reporter for the Baltimore Sun did and ask the CIA if the document is authentic. In fact, maybe Mr. Crutzen can call the Baltimore Sun and ask them if they have a reporter who can be lent to the New York Times for the purpose of conducting a very brief investigation. And then after the Baltimore Sun conducts the investigation for the New York Times, maybe someone at the Baltimore Sun would be kind enough to write the story and give it to Mr. Crutzen, and if Mr. Crutzen can then take it over to his friends at the CIA and ask for their comment, and if they okay it, perhaps the New York Times will then run a story.
I would like to thank Mark Lane for participation with me, albeit by tape, on this show. And he told me, we've communicated since that interview in the subsequent days between then and now. And he told me that he would be coming to New York possibly in 2 or 3 weeks. And at that time, he will appear with me live in the studio for the complete show. And this is Ted Gandolfo saying thank you for joining me, and we'll see you again next week on Assassination USA.